Let's see. Good morning, Mr. Shamanic. Okay, I believe I've captured all of the attendees who should be made panelists. Change. No matter how many times I try to do grid setting, it goes to speaker. Uh, Good morning. I see Ms. Gutierrez on the screen and Mr. Shamanic and Cheryl, our court reporter. I just have a text now from Tanis saying she cannot hear us. Um, She's going to log on and off. So we'll give her a moment to do that. We're on the platform this morning at 8:30 before 9 o'clock public comment.
Can you hear me?
Yes.
I can't hear you.
Uh-oh.
And I tested my sound before I came on. I'm going to log on and off.
All righty. Thank you. While Ms. Fox is doing that, as I understand it, we're going to address three topics this morning. One is the exhibits subject to objection on the basis that they relate to methane. The second is the Namoga's motion to strike certain sections of CCP and NAVA exhibit, particularly the rebuttal testimony of Professor, I think it's Villa, rather than Villa. And we'll go from there to the motion to strike Namoga's newest rebuttal. But let's wait. And if there's something I'm missing that we need to do before 9, please speak up while we're waiting for Tanis. Tanis, can you hear me? All right. Tanis is saying she still cannot hear.
No, I can't. This is very odd, but yes, I can now. When I first came on, I couldn't, but I can. Thank you.
All right. I'm glad that worked. Let's start with the exhibits. I'm gonna pick on Mr. Rose for a minute. Mr. Rose, what? Let's see. I don't see Mr. Rose. Is he with us? He's not. All right, Mr. Heiser. Um, having conducted the methane hearing in January for the OCC, I certainly appreciate the distinction between what the OCC was doing then and what the EIB would be doing now. But I'm wondering if you would offer the most charitable characterization that you could of why folks who perhaps aren't as close to these rulemakings would be confused here. We have heard some about methane in the hearing, particularly from public commenters.
I'm sorry, North, it's not clear to me what motion you're actually addressing at this point.
These are the objections by NMOGA and
You're
IPA-NM.
you're asking about our objection to a couple of the exhibits from either EDF or Clean Air Advocates?
Yes.
Yes, we have our objection, I just think, goes to a question of nuance, Madam Hearing Officer, which is that we think by and large they've been used appropriately throughout the hearing. And I think that we would be satisfied just with a reminder from the hearing officer that this is a rule about ozone and its precursors, and that information should be considered in that light, as opposed to the board suddenly crafting a methane rule based on the fact that there's a methane document in the docket. And with that, that's really all we're seeking here is just a reminder along those lines.
Okay. And I would certainly put that in any report. Number one. Number two, I really think that this board is sufficiently engaged and sophisticated, frankly, about our subject matter that they would not, in fact, be confused. That's just how I feel about this board. But thank you for that.
I must say, Madam Hearing Officer, that I think that New Mexico is well served by the board that it has in this case, which is very actively engaged and obviously has spent quite a bit of time on the issues. So I heartily second that sentiment that you have.
Thank you. Ms. Paranos, anything to add?
Thanks so much, Madam Hearing Officer. I would just really agree with what Mr. Heiser just said. I mean, the information that we've offered with respect to methane is either by way of demonstrating co-benefits. We're never asking the board to directly regulate methane, nor to rely on methane reductions as the basis for a cost effectiveness analysis, nor to rely on any methane only specific control technology. So methane is co-emitted with VOCs that is part of natural gas. And so we think it's appropriate to just speak to the co-benefits of what happens when a regulator reduces VOC emissions as part of an ozone precursor rule. There will also be methane co-benefits. And I guess I would just add that that is very standard practice. EPA does that routinely. They consider co-benefits. Other regulators do as well. Just one example is in 2012 when EPA promulgated the first new source performance standards for oil and gas sources. That was just a VOC rule. They were directly regulating VOCs, but they did estimate the cost effectiveness of methane reductions, and they did talk a lot about methane co-benefits, and they relied on information about methane control technologies that operators had employed as part of the Natural Gas Star program. And so it's a very similar kind of proceeding here as to what EPA did back in 2012. And for that reason, that's why we've included some of this information on methane emissions and control technology that can reduce both methane and VOCs.
Thank you very much. Mr. DeSalen, anything to add? Right now, I'm just planning to overrule NMOGA's objections and IPA&M's objections to the CAA, EDF, and NMED exhibits and CCP. But
excuse me, Ms. North, could you repeat that? You cut out a little bit.
oh, I'm very sorry. I was asking Mr. DeSalen if he had anything to add on my way to overruling the objections based on a possible confusion between methane and ozone. Mr. DeSalen?
Thank you, Madam Hearing Officer. I just want to make a couple of comments here. I agree with what Ms. Paranos said, but I also want to make the point that earlier in this hearing, we heard from a NMOGA economist expert, Mr. Dunham, and he testified about the negative consequences in his view of this rule, things like lost jobs and lost revenues to the state. And so far as I'm aware, none of the parties objected to that testimony or to his report. And without commenting on the quality of that evidence, I think it is generally the type of evidence that this board can and should hear. But by the same token, I think that it's important for the board to hear about the co-benefits, the consequential benefits, if you will, of this rule. So we strongly oppose this motion. Thank you.
Thank you. So just to put it on the record, NMOGA and IPA&M's objections to the exhibits listed um, both in an email and in the attached Word document from IPA&M are overruled, and there will be a mention to the board, at least in my report, and presumably in the parties' post-hearing submittals, um, uh, just being clear.
Madam Hearing
Scope of the
Officer,
rulemaking. Mr.
on
Heiser.
behalf of my fellow counsel, Mr. Heiser, I would note that in your discussion of the proceedings for this morning, you did not specifically mention IPA's objections for this. And so therefore, I think it's not appropriate for you to rule, which is basically on an IPA New Mexico solely on the strength of NMOGA's position on that.
Okay,
And,
I see.
Madam Hearing Officer, I'm sorry I'm late, but I was having logistical problems and I thought we had agreed that the evidence would be admitted subject to our objection and that we'd brief the objection in the post-hearing submittal so that we wouldn't hold up the hearing. So at least that was my understanding with Ms. Fox and others as to why we didn't argue them at the admission of their evidence, and they're putting on their evidence. So
Okay.
if you're going to rule on this motion, obviously I'd want to be heard, but it wasn't a motion. It was merely an objection to admissibility. And it seems to me that we've stated any number of times that the evidence is being admitted subject to the objection, which would be addressed in post-hearing submittal. So I'm certainly was not prepared to argue this as a motion this morning. And as you can tell, I was having logistical problems, and it seems to me arguing it without me being able to actually present it and respond, I think is inappropriate.
All right, thank you, Mr. Rose. I'm sorry, I was going through hold on, Ms. Fox. I was going through my stack of papers that I felt like I still needed to address. And this seemed more straightforward than the others. Ms. Fox, I'd like to move on, unless you have something you need to say right now.
Thank you, Madam Hearing Officer. I was just going to suggest, since it appears that you've already formulated an opinion on this issue, that, and I understand we did have this agreement with Mr. Rose on the one hand. On the other hand, you seem to have addressed this issue fully, and I wonder, but I do appreciate Mr. Rose wanting an opportunity to speak on this issue, and so perhaps that could be done in order to take this issue off the table. Maybe Mr. Rose could present his argument over the lunch hour or some other time today. I don't think crafting that argument would take too much of his time, and it does appear as the Madam Hearing Officer, you understand the issue and you've made your decision.
All right, thank you. We have just a little bit of time left. I'd like to move on to NMOGA's motion to strike CCP and NAVA Exhibit 6, which is the rebuttal testimony of technical witness Professor Villa. Let me just say I carefully considered the motion, the response, and the reply. Certainly want to thank CCP and NAVA for their the excellent written response. Here too, though, I don't feel like I need to hear extensive motion argument because NMOGA's understanding just doesn't comport with my own. And in this case, Mr. Heiser, you have the disadvantage of having, as a hearing officer, someone who has been in the EIB's orbit since the mid-'80s. We have taken a lot of technical testimony that was, in fact, expert legal testimony. We took it in the solid waste management regulations overhaul in 2006. We heard expert legal testimony from the General Counsel of the Municipal League. We took it in, I think, our first Clean Cars hearing in 2008. Certainly heard lots of it from former EPA lawyers in the greenhouse gas emissions hearings in 2010 and 2011 when they were put into place and when they were undone. So it just, the statements here, I think, are simply incorrect. This board is accustomed to hearing expert legal testimony. Are there any questions about that? It's just part of our history, part of the board's history.
For the record, I would simply note that this is inconsistent with this hearing officer's prior resolution on a NMOGA matter, and so we simply adhered to that prior approach that was taken. But I have nothing further to add other than making that note for the record.
Thank you, Ms. Katz.
Madam Hearing Officer, I would just note that the arguments that were made regarding the legal argument that NMOGA put forward were based on the fact that the technical experts that testimony was purportedly attached to were not actual legal experts, and that when you have a lawyer who is a legal expert, then that is an appropriate time to make those types of legal, then you could put that testimony before the board.
All right, thank you for that, Ms. Katz. Mr. Rose?
Yes, first that we join in NMOGA's motion, but secondly, it seems to me that what they're putting forward by the way of legal testimony really isn't expert legal testimony. It's basically legal argument. It seems to me that giving them basically more than one bite at the apple in terms of making legal argument is inappropriate. It's the testimony, as it were, seems to me to be perfectly appropriate if you're going to argue it post-hearing, but I don't think it rises to the level of needing expert testimony. All of us can read the statutes and decide and argue whether or not they're applicable in this context. So I don't think the board needs legal advice from someone outside of the board's counsel, and it seems to me it's really improper factual testimony as well. It wouldn't rise to the level of expert testimony, I don't believe, in a court proceeding. So I don't think it should be here as well.
All right, thank you for that. I certainly have, again, on behalf of the board, a history of navigating the line between the sort of expert testimony that would be taken in a court and the sort of expert testimony that would be taken before an administrative board. And I believe Professor Villa clears that bar. Mr. Iser, did you have something to add? I'd like to move to the most recent motion.
I have nothing.
All right, thank you. So as to Clean Air Advocates, EDF's, and NMED's joint motion to strike parts of NMOGA's proposed rebuttal on LDAR, I certainly read the motion and the response, and a few things came to mind. Certainly, if a lot of economic data would be coming in to surprise any rulemaking petitioner halfway through the hearing, I want to avoid that fundamental unfairness to any petitioner, and am sensitive to any sandbagging or other attempts at surprise in a rulemaking, which doesn't serve anyone's best interest. At the same time, having gone through the table that NMOGA put together at the end of the narrative part of their motion, it seemed like there wasn't perhaps as much data as I feared that was new. So I'd like to spend a little time on the slides and the spreadsheets in particular, because this is where I still had questions. NMOGA states that it's entitled to rebut the statements made on rebuttal that the EIB should conclude from Oxy's joining of the proximity LDAR concept that the measures are feasible for industry. Mr. Heiser, if you would address that, please. I imagine that NMOGA would have been motivated to offer whatever evidence it had on feasibility, regardless of what Oxy was doing. I mean, presumably you felt the way you felt before Oxy reached whatever agreement it reached with the others. Would you address that?
So, Madam Hearing Officer, I think that NMOGA has addressed throughout this hearing its concerns about the frequency and cost of LDAR provisions in the testimony of Mr. Smitherman and a number of its exhibits, which were introduced without objection, including Exhibit 37, which is, for example, our cost model and all the underlying data from the Greenhouse Gas Reporting Program. However, under the Clean Air Act, as Ms. Paranjos has reminded us, and as you yourself just spoke, anytime an industry member does something that may be used as, quote, proof in the Clean Air Act context that something is technically and economically feasible. Clean Air Act advocates witness Dr. McCabe specifically makes that point in his rebuttal testimony, and that means that to the extent that that may not have been an issue, that it's been reopened for us to investigate. Those comments were all made in rebuttal, therefore we could not have responded to them prior to that time frame. On the general issue, though, of LDAR costs and LDAR frequency, NMOGA's position has been pretty clear since its direct testimony that it believes that the costs do not warrant the benefits that are here, although we agree that there should be LDAR overall, as you heard from Mr. Smitherman in his testimony on pneumatics. So I think then that the whole question of us not being able to speak to the relative frequency when that has been an issue that we have placed in front of the board since the inception of this case is counterfactual, charitably, by the other parties.
Thank you. I saw Ms. Paranjos first and then Ms. Fox.
Thank you so much. So I think in particular with respect to EDF's LDAR proximity proposal, there was no testimony nor any type of exhibit even that directly rebutted Hillary Hull's cost effectiveness estimate of our enhanced LDAR proximity proposal. In Hillary's direct, she estimated the reductions and the costs that EDF believes are applicable to our LDAR proximity proposal, and no party in their rebuttal rebutted that particular analysis. That analysis is different than what NMED did because EDF used its own estimate of the VOC emissions that would accrue, as well as our own estimate of cost. And so it is particularly prejudicial to us that on rebuttal, NMOGA is now rebutting our cost effectiveness estimate. I would have been happy to have responded in our rebuttal had they responded in their rebuttal. However, now we don't have that opportunity.
Thank you. Let's see, Ms. Fox and then Ms. Katz.
Thank you, Madam Hearing Officer. All that I have to add to what Ms. Paranjos just said is if I could have screen sharing ability, I'd like to just briefly show you Ms. Hall's testimony, just so you have a sense of the detail of it. Thank you. Let me see. Go. So Ms. Hall presented pretty detailed testimony in her direct testimony on the estimated costs of our LDAR proposal and the estimated emissions reductions. I have 7 pages up here where she describes, how they got to the number of wells, for example, that would apply. the methodology that we use to estimate the number of homes, or EDF, number of homes and places of residents and business that would apply, methodology to estimate leaks, cost effectiveness of the proposal, and even comparing the cost effectiveness of the proposal with other jurisdictions. So they're all backed up with numbers, and then this testimony is backed up with numerous exhibits as well. And so if NMOGA wanted to rebut the cost estimates and the emission reductions, they should have done it in rebuttal, not in response to a comment from Dr. McCabe, who is not an economist, that merely said that the fact that Oxy is joining in this proposal shows that it's technically feasible. That's what they're hanging their hat on to provide this kind of evidence rebutting the proximity proposal. When they said in NMOGA's rebuttal, they did not mention the proximity proposal at all.
Okay, thank you, Ms. Katz.
Thank you, Madam Hearing Officer. And NMED's concern was mainly regarding the NMOGA model plant issue and the spreadsheets that NMOGA has now put forward as Sir rebuttal. And in their slides 10 through 11 of the Sir rebuttal. And they point there in their table that they included with their response, they say that they provided all the data in their exhibit 27. You know, that is the GHGRP data. And so they had that data, and then they just put the final numbers that they had in their testimony. And now in rebuttal, but they didn't show any of their work on that or how they got to those numbers. And that one page, tiny little font GHGRP data, there's nothing intuitive as to how they went from that to these model plant numbers that they put forward. And so, you know, it's incumbent on them to show their work, how they did that. And now they're putting that forward in slides 10 and 11 and these spreadsheets. And, you know, and those spreadsheets, I'll point out that if you look at the file data, they were created on July 22nd and July 26th. So they clearly had them, or they had done the work and had that methodology that they could have and should have provided with their direct testimony or their rebuttal, but they didn't. And so it's just really not appropriate for that to come in now in the middle of the hearing as Sir rebuttal. And that was the department's main issue.
All right, thank you. Mr. Heiser, is there some reason the data wasn't provided earlier so that it would not be a surprise?
Well, Madam Hearing Officer, it was discussed, and the basic point that we had made, which is that the greenhouse gas reporting data, which includes the equipment counts, shows that the equipment counts that were being used is pretty clear in terms of its import and impact, and all that data is publicly available to anybody. We didn't think it was necessary to actually show the math at the level of 2 times 2 equals 4. But the department said that they were having trouble following the math. And so we're merely providing the math that shows that what we did before is what we said we did. So I don't think that there's any question of surprise here. The NMED devoted like 8 pages to our economic analysis and the cost data. They clearly understood what the import of our analysis was. They disagreed with our contention about the greenhouse gas data. And so this is really just supplying additional information to help people understand what that point was. There's no question about surprise. And they've had since last Thursday to look at this. It's not like we sprung this on them last night, which has been sort of the practice for turning in Sir rebuttal testimony. So I don't believe that the department has any real thing that it can say. Plus, the department itself is changing its position constantly about what its frequency is, and that puts the cost effectiveness of its constant changes in frequency certainly at issue. We couldn't respond to that. They did that after the rebuttal deadline. So I don't think the department has anything really to say here. In terms of Ms. Paranos and the environmental groups, the quick and simple response to that is that our principal beef here is with the department's data, and our response is to the department's data. And so while we believe that the issue of cost effectiveness is certainly joined, we aren't particularly proposing to survey about the specific numbers that are in their data, or our focus is on the department's data. And that's what we're showing here.
All right. Oh, Ms. Fox.
Just very briefly, Madam Hearing Officer, so I'm not sure, but maybe I heard Mr. Heiser just say that he's withdrawing the slides with regard to the occupied area
I
proposal.
am withdrawing them because we placed an issue frequency from our direct testimony thereon. That
Okay,
means
it's,
it's an issue before the hearing, and if they want to rely on their data, they may. But we're certainly entitled to rely on the department data on the frequency issue.
just again, in order to really understand what's going on here, the department put forth their LDAR costs and estimated reductions in a spreadsheet that they put online in June, and then put that in their direct testimony. And in NMOGA's comments in its direct case, in its red line, the comments that were struck because they were inappropriately filed, NMOGA specifically referenced that spreadsheet, which is, I mean, it's very complicated. I'm sure, Madam Hearing Officer, you've seen it. I'm just gonna throw it up on the screen here. Hold on.
I see. I'm holding it, Ms. Fox.
Okay, great. And so, you know, NMOGA was fully aware that of that spreadsheet. It referenced it in its direct case. As Ms. Katz has pointed out, the two spreadsheets, which are really the most problematic evidence that they're offering at this late date, were created before NMOGA filed its direct case. And so it really is unfair not to have shown that evidence now. And we also question whether Mr. Smithern is the witness who developed that table, those spreadsheets, and is the correct witness to present that evidence.
All right. Thank you for that. We're now, oh, Ms. Katz.
Sorry, Madam Hearing Officer, you froze, so, and I had raised my hand. I don't know if you called on me.
I'm sorry if I froze. Please, Ms. Katz.
I just simply wanted to respond to Mr. Heiser's statement that NMedia has been changing constantly. And I just wanted to say that it's true in our September 7th filing that we had proposed some changes to the LDAR frequency, but that then 1 week later we changed it, and that simply went back to what it was before. So the suggestion that there have been, you know, those were totally unanticipated and difficult to understand. It simply went back to what it had been the whole time before. So it changed for a week, and then it went back to exactly what it was throughout, since it was as it was in May when we filed the petition.
All right. Thank you. So we are now a few minutes past 9 o'clock. We do have 4 public commenters this morning. If you're on the platform to offer public comment, I will invite it in just a moment. At this point, based on my understanding of the board's rulemaking procedures in 20.1.1, including partly the responsibilities of the hearing officer, partly the definition of record proper, for example, what I'm inclined to do, because I really am sensitive to detailed information coming in as a surprise. I do think it's fundamentally unfair to the petitioner to handle it more as an offer of proof. That is to say, to exclude it, but allow NMOGA to describe what they would be offering if they were allowed to offer it, because it will remain in the record proper for better or worse. We can talk further about this after I accept public comment if we need to have more discussion. Okay, board members, if you're on the platform, you can turn on your screen now. Thank you very much for waiting while we discussed some procedural matters just now. Members of the public, my name is Felicia Orth, hearing officer conducting a hearing in EIB 2127, a rulemaking on ozone precursors. We have public comment sessions every day at 9, 1, and 5. This morning, I'll be calling on the public who reached out to the board administrator, and in this order, Representative Andrea Romero, Representative Liz Thompson, Dwayne Chili Yazzie, and Adam Horowitz. If you're on the platform and did not communicate via email with the board administrator, I am still happy to accept your comment. Please reach out through the chat, which is enabled for everyone. Public comment is taken under oath, is taken by audio, not video, and is limited to 5 minutes. So let me look for Representative Romero. I'm not seeing Andrea Romero. Let me look for Liz Thompson. All right. Can you hear me, Representative Thompson? Hello?
Yes, I can hear you. Thank you.
Oh, good. I can
Are
hear
you ready?
your voice. I can hear
Oh,
your voice clearly. If you would please spell your name.
okay. Liz, Liz Thompson, Thomson.
Thank you. If you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you. I'm going to start your 5 minutes now.
Thank you. As I said, I'm Representative Liz Thompson. I represent House District 24, which is in the Northeast Heights of Albuquerque. But I'm speaking on behalf of Kids Lungs statewide. I have served the previous 6 years as co-chair of the New Mexico Tobacco Settlement Oversight Committee. And one of our main goals is to keep youth from using tobacco, because we know how important lungs are. I support Governor Michelle Lujan Grisham's call for nation-leading oil and gas pollution rules. To achieve that goal, the Environmental Improvement Board must strengthen the New Mexico Environment Department's proposed ozone precursor rules to protect those living closest to development. As a mother and a grandmother, my top concern is the lungs and health of all kids, my kids and grandkids included. Every child in our state has the right to breathe clean air without industry threatening that those same kids' schooling will be taken away with these rules. That is not the case. Every industry, no matter what it contributes to society, has an obligation to be a good corporate citizen. Industry contributes to our schools and our state budget, but they also make billions of dollars in profit by extracting publicly held resources off of our public lands, and they export most of that profit out of state. Spending a minuscule amount to protect our kids' lungs is the least they can do. These rules are a basic courtesy to the people who live close to industry, and threatening to leave the state because of the same industry rules that it follows in Colorado is unacceptable. In fact, Colorado has successfully implemented more frequent inspection schedules for homes and schools that have oil and gas wells in their backyards, and New Mexico should do the same. Also, setting strong rules at the state level sets a good bar for forthcoming federal methane rules that can help protect New Mexicans from states like Texas, who don't have the same kind of regulations. Oil and gas pollution are taking a toll on all New Mexicans' air, water, and health. But rural communities, tribal communities, children, and the elderly are especially at risk. And I will note that I grew up in the Crown Point area. I grew up in Crown Point. More than 130,000 New Mexicans live within a half a mile of oil and gas development, including communities of color that face disproportionate impacts from climate change and air pollution. Leaks due to equipment malfunction and lack of maintenance account for 70% of the oil and gas industry's emissions statewide. I appreciate the strong rules that NMED has put forward to a strong, and they have put forward a strong proposal. Here are 3 critical improvements that EIB should make to protect communities and address major sources of pollution. 1, protect those living closest to development by requiring more frequent inspections to find and fix leaks. 2, ensure strong requirements for operators to control pollution during completion of an oil or gas well as when they redevelop an existing well. And number 3 is strengthen requirements to cut pollution from pneumatic controllers that are used in oil and gas production. The devices are the second largest source of oil and gas methane emissions in New Mexico. NMED should require companies to inspect pneumatics for leaks and accelerate the timeline to retrofit equipment with zero bleed or zero emission pneumatic controllers. Thank you for taking the time to listen to me. Thank you for all that you do, especially to protect New Mexicans' kids. Thank you so much.
Thank you, Representative Thompson. Let me look for Dwayne Chili Yazzie. I don't see him by name. Perhaps call-in user number 5. Caller number 5, would you tell us who you are? Caller 5? Hello? Hello? Caller 5? Okay. Let me move to Mr. Horowitz. Mr. Horowitz, I've unmuted you. Can you hear me?
Yes, I can. Thank you.
If you would spell your name first, please.
It's Adam, A-D-A-M, Horowitz, H-O-R-O-W-I-T-Z.
And if you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 5 minutes now.
Thank you. Good morning, all, and thank you so much for accepting public comment on this important methane pollution rule. My name is Adam Horowitz, and I'm a New Mexico resident and a co-founder of 3 national nonprofit organizations working at the intersection of faith, community, and social and environmental justice. As a person rooted in a faith tradition which holds all of creation as sacred, and as a citizen of the US, one of the world's top contributors to climate change, I believe we face a profound moral responsibility to do everything we can to protect life on our precious planet. My work brings me into contact with many young adults who are fearful of the climate chaos in the world they are inheriting. Earlier this month, the results of a worldwide survey of young people ages 16 to 25 showed that some 60% were very or extremely worried about climate change, and 65% felt that governments were failing young people when it comes to climate change. Here in New Mexico, a state that emits more than 1.1 million tons of methane each year, a state that made national news for its methane cloud visible by satellite, we have a chance to make a difference and to model a government that is not failing its young people. But it will take more effort. We have many young people and children living within critical ranges of the oil and gas industry in New Mexico whose health is adversely affected by these operations. We have a responsibility to care for our children and youth whose voices are often not heard in forums like these. While the Environment Department has put forward a strong proposal, more work needs to be done to protect communities and to meet the governor's aspiration of nation-leading rules to cut pollution. Specifically, the Environment Department should require more frequent inspections to find and fix leaks, ensure stronger requirements for operators to control pollution during the completion or redevelopment of an oil or gas well, and to strengthen requirements to cut pollution from the very high emissions pneumatic controllers that are used in oil and gas production. So let us prove to our young people and to frontline communities that we are not willing to sacrifice their health and well-being for convenience and profit. Let us do our part to curb climate change and ensure that young people in New Mexico and around the world have a livable future. Thank you.
Thank you very much, Mr. Horowitz. Let's see, let me look for Representative Romero again. I don't see an Andrea Romero in the list. And I don't see Dwayne Chiliazzi. I'm going to go back to caller 5. Caller 5, can you hear me? Nothing there. Okay. There are several more opportunities to offer public comment in this hearing, 9, 1, and 5 every day. Please reach out to Pam Jones, the board administrator, to identify the slot in which you would like me to call your name. Let's return to the technical case at this time. Board members, we heard some argument between 8:30 and 9. We did not quite finish the conversation. And at this point, let me just sum up, and I'll invite council to come back on the screen if they have questions. I denied the motion to preclude Professor Villa from testifying, noting that I've taken a lot of legal testimony as quote unquote technical testimony. I've served the Environmental Improvement Board, a variety of boards over the years, 1999, and the Environmental Improvement Board has a long history of accepting legal testimony, if you will, expert legal testimony in its rulemaking hearings. I also used to accept it at department hearings in permitting and enforcement cases. And I believe Professor Villa clears the bar, as I said, for providing knowledgeable testimony that may assist this board in its deliberations. So we'll hear from CCP and Nava's witness on rebuttal. The motion to strike some of NMOGA's rebuttal was definitely more challenging in my view.
Madam Hearing Officer, you're cutting out, at least on my system. I don't know if everybody else is hearing that.
Oh, I'm very sorry. I'm going to turn off my video then, just to get through this. I'm not getting any messages on my screen, so I'll just turn off my video. Okay, is this better? Yes? Okay, I see Madam Chair nodding. So we if I could sum up, although NMOGA has had certain data around the feasibility of some of the LDAR provisions since July, it chose to offer it in these spreadsheets just a handful of days ago after the hearing had started. The other parties don't really have an opportunity to study the data and provide their own analysis of it with just a couple days left in the hearing. My read of 20.1.1, which is your rulemaking procedures, in terms of the duties of the hearing officer and also the definition of record proper, say to me that I cannot strike these documents in the sense of directing the board administrator to reach into the files and remove them. That's not, in my mind, either possible or desirable, particularly because this board may disagree with my conclusion that this new data should be excluded and not presented today when we're doing LDAR, on the basis that really no rulemaking petitioner should be surprised by new data toward the end of a hearing, particularly when, in this case, the rulemaking petitioner has been so vigorously engaged in negotiating on all fronts, really, throughout the rulemaking. So my read of your procedural rules is that I will grant the motion insofar as I would like to say to NMOGA, you cannot present this surprising data today as in the name of Sir Rebuttal. Having said that, again, I have to contemplate the possibility that this board would reach a different conclusion, at which point my suggestion to you would be to allow the other parties, particularly the department, who would be surprised by this new data, an opportunity to actually study it and develop their own answer to it. But that's not going to be possible this week. It's not something they can do overnight, at which point I think you would have to schedule another day of hearing for some time in the future. Do the board members have any questions about that?
Madam Hearing Officer, if we may, we have a lot of questions. Are you excluding all of Mr. Smitherman's testimony or just the two tabular Excel spreadsheets?
Right now, the two spreadsheets, and again, what I'm seeking to exclude again is the surprising material, not that portion of Mr. Smitherman's testimony that was based on information that was already included in his direct. So we may need to keep talking about this. Let me ask, though, the board members first if they have questions. Board members, questions?
Thank you, Madam Hearing Officer. I did have the opportunity to listen in on some of the discussion before the meeting, so I think I understand, how you were phrasing this. So I'll leave it to some of the other board members if they have questions.
I'm gonna take the opposite. I came in late on the discussion, so I wasn't really sure what the issue was. Was this testimony that we already heard or that we were going to hear?
This is NMOGA's LDAR testimony. We were going to devote most of today to LDAR, which is why we were having the discussion before public comment today.
Okay, I'm clear on it now. Thank you.
Mm-hmm. Other questions? All right. So we can go back to the Mr. Heiser, if you want to come back on screen, and any other council who'd like to come back on screen briefly. As I understand it, please correct me if I'm wrong. what I would be excluding specifically would be slides 52 to 56 and the Excel spreadsheets.
And I believe, Madam Hearing Officer, the department was asked, the slides 10 and 11 that are associated with those spreadsheets.
That's right. And I wondered, obviously about the department's September 16th final rule proposal following rebuttal testimony, but I think you've explained that. Let's see here, Ms. Fox.
I have nothing more to add. Thank you, Madam Hearing Officer.
Thank you, Mr. Rose.
Yes, my understanding of what Mr. Heiser was offering were demonstrative exhibits, so they weren't being offered into evidence in any event. So I don't know that you can necessarily strike them because they're not part of the evidence. I thought your ruling was with respect to the testimony that would be adduced in respect to those slides. So I think what you're talking about here is excluding Mr. Smitherman from testifying on those issues as opposed to excluding the exhibits. So I just want to make it clear that you're ruling on the admissibility of his oral testimony in sur rebuttal on those issues.
Yeah, sorry. Ms. Fox?
Thank you, Madam Hearing Officer. It's my understanding that NMOGA was offering the 2 spreadsheets as exhibits, so those would be excluded from evidence. And I agree with Mr. Rose that what we said in our motion is that with respect to the slides, that they should be excluded. They are demonstrative exhibits, so they won't technically come in, but in all associated testimony. And so while Mr. Heiser can make an offer of proof, that doesn't mean he gets to offer all the testimony in support. It's only an offer of proof.
That's what, if I didn't say that clearly, thank you, Ms. Fox. Let's see, I see Ms. Paranos.
I'm just on the screen just so that I'm here, but I understand what you're saying, Madam Hearing Officer, and I appreciate what your ruling is.
I think, Madam Hearing Officer, that we think that the proposal to exclude the NMOGA model plant, which Mr. Smitherman addresses repeatedly in his direct testimony, is not appropriate because the board is entitled to hear the explanation of why NMOGA did that so they can understand the cost context of Mr. Smitherman's testimony. The department clearly understood, because they devote several pages to the differences in the model plant, what those issues are, and they are, I might say, incremental to what's already in the record. And the model plant data is already in the record as an admitted exhibit for that. So I don't believe that there's any prejudice to the argument about whether there are 6 or 7 of a certain component at the model plant to the department.
I'll let Ms. Katz speak now. My memory was, though, that all the department was doing when it addressed the model plant statements from NMOGA was pointing out that NMOGA wasn't supporting those statements with data. Ms. Katz, do I have that wrong?
Yes, there were 2 different model plants. There was the CTG model plants, and were NMOGA's own model plants. And so we're not speaking about the CTG model plants, but NMOGA's model plants, we said that there wasn't the data. They didn't show how they got the numbers. And my understanding is that those spreadsheets show that, and that should have been provided as part of their direct testimony.
Very similarly, Madam Hearing Officer, the EPA's basis in the CTG document for the model plant also is not in the record in that same way. And so in the interest of a level playing field, I think it's perfectly appropriate for there to be a discussion about whether the model plant has 6 or 7 of certain component and what the emissions impacts of that are. And that's something that's useful for the board to understand.
Okay.
However, the EPA information is in EPA's record, so we don't have to go create it ourselves. And that is the problem with NMOGA's model plant, and they are they are providing spreadsheets now that show how they got where they did. And that was not obvious or clear from what they had presented in their direct testimony.
All right, thank you, Ms. Fox.
Thank you, Madam Hearing Officer. You know, as I'm looking through the other demonstrative slides that we moved to exclude, I am seeing that some of the data in some of the other slides besides the two that Ms. Katz referenced is data from the spreadsheets that are excluded. And I'm not able to go through all these slides right now very quickly, although I can later during a break, to identify those which reflect data in the spreadsheets that are being excluded. And so those slides should be, at least the testimony around those slides should be excluded as well.
All right.
Madam Hearing Officer, those spreadsheets are merely the same thing as what's in Mr. Smitherman's direct testimony, and therefore the fact that they may also be in the spreadsheet doesn't change the fact they've already been testified to and admitted.
All right, thank you. It seems that we may need further discussion as the testimony is offered, and I'm not sure we're going to be able to do any more as part of a general discussion before we actually get to Mr. Smitherman and the slides. So, Mr. Heiser, are there other things we can do before we actually get to the testimony?
I guess, Madam Hearing Officer, I'm not sure what other things you're asking us to do.
So when you put on Mr. Smitherman on Eldar, I would like to navigate a distinction here between testimony he would be giving that was based on data already in the record, and testimony that he might have given based on data that was presented only on September 23rd. When we get to the testimony related to the spreadsheets and the other new information from September 23rd, I'd like you not to go through Mr. Smitherman's testimony, but instead to offer a description of what he would be testifying to were it not excluded on the basis of surprise.
I guess, Madam Officer, is subject to, I think, our ability to request the board to review this decision to essentially exclude much of the cost information from industry about one of the significant provisions of this rule, which is our understanding of what you're attempting to do.
Yes, because I understand completely the board is the decision maker in this matter, but I think it's important that the board understand that if in fact they're to take this new and surprising data into account, that in fairness to the petitioner and the other participants in this proceeding, they would have to schedule another day of hearing at a time that allows for mitigation of the surprise. It's just not something they can do by Friday.
So, Madam Hearing Officer, one last question before you move on. My understanding is that we are to use the information in Mr. Smitherman's testimony as it was in his direct. We may draw reasonable extensions from that information, because otherwise you're also saying that NMOGA can only repeat what it said previously without any opportunity for surrebuttal. Is that your intent?
No, my intent is to carve off that surrebuttal, which is based on surprising information that should have been provided earlier in this process.
Okay. Subject to that understanding and understanding that we will certainly be challenging that characterization before the board, we will do that, and where you believe appropriate, we'll be happy to offer proof at that time.
Thank you very much. Ms. Fox?
Madam Hearing Officer, sorry to prolong this, but thank you. So I think in the interest of efficiency, I think it would be helpful if we did identify the specific slides in Namoga's proffered SIR rebuttal that reflect data in the spreadsheets that have been excluded. And then I think that we won't get into arguments during Mr. Smitherman's presentation, whether a particular slide is allowed in or not, or whether particular testimony on that slide is allowed in or not. And during a break, you know, we can endeavor to identify those slides that reflect information in the spreadsheets that have been excluded.
Right, thank you very much. As I understand it, we're going to turn then from this discussion. We've had public comment. We're going to go to Ms. DeVore of the National Park Service. I see Ms. DeVore. Thank you for coming onto the screen, Ms. DeVore. I don't know if I've sworn you before.
You swore me in when Mr. Beaumont gave his testimony last Monday.
All right.
We can do it again if you feel comfortable.
No, that's fine. You're still under oath. Please proceed with your presentation. Do you need screen sharing?
Yeah, I do. Yes.
Excuse me 1 second. I'm having technical issues. Okay, thanks. I don't know why that keeps happening.
Before I share my screen, I'm going to be referring in this rebuttal and SIR rebuttal to the Park Service.
Excuse me 1 second.
Oh.
Sorry about that. It happened again.
Cheryl, you might want to turn off your video.
No, it's on my software.
Oh, okay.
Yeah. Can we just take 2 minutes and let me restart it?
Certainly.
Thank you. Sorry.
Madam Hearing Officer?
Member Garcia.
Thank you. While we're taking a moment, if I could ask a question regarding the previous discussion, if you could let me know, I'm a little confused as to whether or not there would be post-hearing submittals that address the slides and data that may be excluded at this time. Would it be discussed in post-hearing submittals later or not? I was confused about that.
Yes, I believe each party will be addressing a variety of legal topics in their post-hearing submittals. And I would certainly encourage NMOGA and the other parties to address it there. Let's see, I see Mr. Rose on screen. Now we're not, Cheryl, are you back or no?
Yes, I am.
You are, okay. So I was just responding to a question from Member Garcia about post-hearing submittals. Let's see, Mr. Rose, do you have something to offer?
Yes, and that was in response to Board Member Garcia's comments. While this can be raised in post-hearing submittals, my understanding under the board's rules is they can review your determination on admissibility of the evidence even before post-hearing submittals are due, depending on if NMOGA intends to raise them directly to the board. So I mean, given the nature of this, they may be raised even before we get to post-hearing submittals. So I wanted to make sure that the board member had a clear picture of this. I don't know what advice the board's counsel will give them as to how they should address this issue, but I think that's something between the board and its counsel.
I agree with you, Mr. Rose. Thank you, Member Garcia. Let's see here. I have a question from Member Vice Chair Trujillo Davis. If you'd like to put it on the record, go ahead, Vice Chair.
Yes, I was just kind of following Member Garcia's question here. Does the board need to make a decision? Do we need to vote on a decision here? I'm just kind of curious about our next steps.
So my suggestion would be to allow your counsel, who I believe has been on the platform for the entirety of the hearing, to consider this question and to advise the board. I'm not going to ask her to jump onto the discussion, onto the record right this second. She may want to offer her counsel to you privately, which is certainly an option for her. So when we next break, I will reach out to your counsel and come back with an answer, or she will come back with an answer one way or another.
Okay, thank you very much.
Sure.
We would want to reserve our ability to make a formal motion if appropriate in this order.
All right. Thank you very much, Mr. Heiser. Let's see. Ms. DeVore, we are back to you. If you would spell your name for the transcript, please, and then proceed with your statement.
Okay, so Lisa, standard spelling, and then DeVore, D-E, B as in Victor, O-R-E. And I was about to say, before technical issues and logistical conversation, that I will be referring to the National Park Service's exhibits from rebuttal. So exhibits B, C, D, and E, as well as our notice of rebuttal statement. And I may also need to pull up some of the, let's see, it's the department's rebuttal exhibit 23, just depending on the conversation and questions. So with that, I am going to go ahead. I'm going to formally introduce myself. So I'm Lisa DeVore with the National Park Service. I am the Intermountain Region's Air Quality Specialist. The Intermountain Region spans from Texas to Montana. So I manage the states within those regions for air quality issues. I have over 15 years of experience in the air pollution control industry. I came from the Colorado Department of Public Health and Environment, where I worked on policy issues, rulemakings, and engineering analyses. So I held multiple positions with that department, including an engineer, policy planner, modeler. I have a Bachelor of Science and in Environmental Engineering and a Master of Science in Civil Engineering from the University of Colorado at Boulder, and I hold my professional engineering license in the state of Colorado. I also worked on the recent rulemaking in Colorado for engines 1,000 horsepower and above. So with that, I'm going to share my screen. Can we all see, it should say the data support the need for this rule? Anybody?
Yes, we see it.
Okay, I just want to make sure before I go ahead. So I'm jumping in. So Mr. Vimont last Monday presented some of this presentation, and we are now continuing this for the engines part of this conversation for rebuttal and surrebuttal. So just going back to, I'm just going to summarize this slide real quick, just to have everybody remember how we discussed Carlsbad Caverns and how the air quality at that park frequently exceeds the standards for ozone. The air quality there is actually on the order of cities like Santiago, Chile, and Mexico City, Mexico. And I think that's just something that's important to note for all of us to remember when we're having these conversations about all these aspects of this rule, what's at stake here. So then the information presented highlights the need for both NOx and VOC reductions. And at the time of the rebuttal, we had thought that the proposed engine and turbine standards were going to be like 1,000 horsepower and up for engines, and then and there was only one category for that, and they were lower than what any MNED came out with in their rebuttal statement. So I'm going to talk a little bit about that, and that's where I may need to pull up their tables. And then the turbine standards also subsequently changed. So the ones I'm going to show you here are a bit outdated, but I can still refer to in rebuttal where we're at now. So the ones that were proposed have been similar, and there's been a lot of conversation about the similarities and some of the dissimilarities of the standards in other states, including Texas and Pennsylvania. There's also standards that are more stringent. So we have standards in California that are more stringent. Some of the standards in Texas are more stringent for non-attainment areas. I mean, we're treading a line here where we're trying to get, New Mexico is trying to get ahead of being non-attainment, but it's important to be thoughtful about, coming back again and again and what kind of standards you may be looking at and what's also possible. So, we have Colorado just to the north. From a lot of the information from New Mexico, there is a lot of similarities between Colorado's recent rule and what's being proposed today. However, there are a couple of stark differences. Oops. All right, so I don't know why I cannot get rid of this. Okay, there we go. So, based on the example from Pennsylvania's requirements, I'm not going to really talk a lot about this because we're in a different place now. But, rich burn engines, it's easier to control rich burn engines than it is to control lean burn engines. I'll completely agree to that fact. And so, some of the lower limits for the rich burn engines are appropriate. One thing I would like to note, and kind of combining rebuttal and surrebuttal here, but I would strongly encourage New Mexico to come back and look at standards for engines lower than 1,000 horsepower, with the exception of the 500 horsepower that remains on the books for the future. So I think at this point, there's so much going on with this hearing. I think it's just sorting out some of the issues with the engines that are on the books for over 1,000 horsepower, and we do not have any concerns with the 500 rich burn. It's really for more of the specific categories. So for lean burns, we do assert that it's possible to control, again, under 1,000 horsepower, and we are not bringing a lot of this back up at this point. We assert that New Mexico should go back and visit these in the future. I would note that there were plans for Colorado to go back and visit smaller engines, so I encourage New Mexico to keep an eye on that rulemaking whenever that occurs. It should be fairly soon. And as far as our turbines go, we're also not going to talk a lot about this today. Unfortunately, the staff member that was more familiar with this topic had surgery on Monday and can't be here. But we still encourage New Mexico to look at revisiting turbines in the future. Right now, a lot of the limits are due, like as NMOGA, some of their exhibits, it's been back and forth, but is New Mexico trying to just duplicate the requirements of Quad K, or are you trying to go further? So I think that's something important to think about. And so then some other notes that I want to make is that the removal, and now I'm going to move to the tables so we can look at them. Zoom in a little bit. But so a couple notes here is that, so the removal of or installed. So for these areas that are subject to this rule, this means that engines from other places can still be moved into these areas, and we'll be looking at, they won't be subject to these rules. And so I think it's that the removal of this language is a really key point. You know, in Colorado, when we were working on this rule or on a similar rule, tried to be really thoughtful about relocation and engines not being moved around into these areas that have these ozone issues to become dumping grounds for old engines. And those can come from out of state, or they can come from other areas in New Mexico and would be subject to this rule. So I think that's really something that we feel strongly should be pulled back into the rule and not be removed. And then the second point I'd like to make is that this 2 grams per horsepower hour here for 4-stroke lean burn engines. So in Colorado, the standard for all lean burn engines is 1.2 grams per horsepower hour. And so I think that should be the ceiling. And right now, this number is higher. We don't have any opinion on the carbon monoxide standard or the really VOC standard. So those match. This table doesn't match Colorado, but some of the proposed numbers match Colorado. So the 2 grams per horsepower hour for CO matches Colorado. You have to have a balance between NOx and CO. So it will admit that I think that's appropriate, just because we're really trying to get at NOx here. And there does need to be a limit on CO so that operators are applying their controls properly and we're not seeing levels of CO shift into high realms, but at the same time, you don't want it so low that it's not technically feasible for operators to work their controls properly. So those are the comments that I had. And with that, let me see, let me make sure I didn't miss anything here. I just want to really reemphasize that we think it's really important those couple of things be strongly reconsidered in the final rule by the board. So again, the addition of installed needs to come back, and that actually applies for engines and for turbines in this case. So, if it isn't taken out, then, sorry, if it isn't added back in, then you can move those type of equipment into these areas and they won't be subject to the rule. So I think that's really important aspect to think about. We just want to also point out that the modeling was originally assumed, much greater reductions, and the revised standard is much lower. And we need to reduce both pollutants, so NOx and VOCs, if we want to see the ozone levels also be reduced in Carlsbad and in other areas in New Mexico that are close to the ozone standards. So with that, I will take questions. And I will stop sharing my screen if I can figure out what's going on here.
Thank you, Ms. DeVore. If you are a party or counsel and have questions of Ms. DeVore, please turn on your camera. See, I see Mr. Rhodes. Mr. Rhodes?
Yes, Madam Hearing Officer. I just need some clarification from Ms. DeVore, if that's possible. My understanding is you're testifying on behalf of the Park Service, is that correct?
Yes, the National Park Service.
And I'm just wondering, since I didn't see an attorney enter an appearance in this matter on behalf of the Park Service, has your testimony been vetted with management of the Park Service before it's been offered? And does it represent the official position of the Park Service?
Did report out that we would be testifying in this hearing to National Park Service management. Yes, and we have coordinated with, so for the Park Service, we don't call them lawyers per se, they're solicitors that help with the Department of the Interior, and we have coordinated with them as well.
Okay, and they have an office in Albuquerque, and there are solicitors here. I'm just curious as to whether it was your testimony or had been vetted through management and been approved as the official position of the Park Service. I have no further questions.
Okay. All right. Thank you. I see Mr. Swift. Mr. Swift.
Thank you, Madam Hearing Officer. Ms. DeVore, my name is Whit Swift. I am counsel for the Gas Compressor Association. And I just had one again, at least starting off more clarifying, you discussed, and in your Exhibit B, you had included some recommended standards for those smaller size category engines, that is generally under 1,000 horsepower. But then in your discussion, in your testimony that you've just given us, you've represented those as I guess, things that you want New Mexico to consider in a future proceeding, but you're not necessarily recommending them as part of this particular rulemaking. Is that correct?
Yes. So we have changed our position on that fact.
Okay. All right. Well, with that clarification, I did have some questions for you about those smaller engine source or size categories, but I will not, in the interest of keeping things moving along, I won't drag you through them, and I'll help keep things moving here with the hearing. Thank you very much for your testimony.
Thank you. Mr. Heiser?
Yes, thank you, Ms. DeVore. I'm Eric Heiser, and I represent the New Mexico Oil and Gas Association. Appreciate your appearing here today. I know that folks from the Park Service are quite busy. You expressed some concern about the installation or install and how that was removed from, I believe, Table 1 and Table 2, and a concern that that might allow other turbines or engines to be brought into an area not be subject to the rules. Is that correct?
Yes.
And wouldn't those units, though, regardless of where they were first installed, still have a construction or reconstruction date on them?
They would, but so if they're brought in from out of state, then it becomes more difficult for the state to figure out if they're going to be subject to the rule or not.
Yes, but isn't it the obligation of the owner or operator of that unit to provide that information to the state as part of its either permitting or notice provisions?
Okay.
Okay, thank you. But if that date is available, then that would answer your concern about making sure that they were appropriately classified as between tables 1 and 2, would it not?
But I think, yeah.
Okay. Thank you. I don't have any other questions. Appreciate it.
Thank you. I think I saw Mr. Bach briefly. Are there any other questions from, oh, there you are, Mr. Bach. Go ahead.
Yes. I just had two brief questions. If I could have sharing privileges. Okay, let's see. Just wanted to look at the Colorado language. Let's see if this works. I don't know if that's. Is this, can you see the Colorado language there?
Yes.
So I appreciate your testimony, Ms. DeVore. I just wanted to make sure I understood two things. You mentioned you worked on this Colorado rule, right?
Yes.
That was last year.
Sure.
Um,
It was really 3 years long, but yes, we ended up in rulemaking last year.
And I wanted to ask first about this issue about the installation date. So, and I'm not familiar with the rule, I didn't work on it, but it seems to me that Colorado does make it based on the installation date, that if that a newly installed engine is considered subject to the standard. Is that correct?
Yes.
So they use the word placed in service. So the in-service date. Okay, so I think that's helpful. And the second, I just wanted to make sure I understood too. So with this, these 4-stroke lean burn engines, I think that I understood you to say that New Mexico had proposed a standard of 2 grams horsepower hour. Is that correct?
For the class size, yes, for one of the class sizes. Mm-hmm.
And Colorado has it at 1.2.
So I feel like that should be the ceiling. if not lower. Especially when companies have, room for alternative compliance plans, which is the case for both Colorado and New Mexico's rules.
Okay, that's very helpful. So we should probably be taking a look at what they did in Colorado. All right, thank you so much, Mr. Bohr.
Madam Hearing Officer,
Yes.
is the exhibit that Mr. Bach showed her, is that in the record somewhere?
That's one of New Mexico's exhibits.
Okay.
Look at their list
Want
to
to
see
make
which
sure
one
the
it is.
record is clear what we're referring to here.
So that's,
Yeah,
New
Mr. Rose,
Mexico
I
filed
just
that at the beginning of the hearing.
I just pulled this up. This is the
Excuse me,
One at a time.
one at a time, please.
At the hearing, the court reporter seems to be having problems discerning who's saying what to whom. So that was the only question, as to where in the record is it, so that the record's clear what you're talking about. Because the written transcript only refers to the screen, and the board won't have in front of them what you're referring to.
yeah, thank you, Mr. Rose. That's a good point for the record. So I had just pulled up the 5 Colorado Code Regulations, section 1001-9-E-1. I pulled it up online, but I think that it's, don't think there's a dispute that that's what the regulations say.
And I assume that's Reg 7, or it's referred to, I think, throughout the hearing as Colorado Reg 7. Is that what, or is this another Colorado reg?
It's Reg 7.
Okay, that's all I needed. Thank you.
And I just put the code section in the chat, if anyone. Thank you.
Mr. Bach, I'm sorry. Chat is only enabled to the host. If you would, I'll read it. It's 5 Colorado Code Regs, section 1001-9-E- I imagine that's an I. Are there capital?
That's a 1.
Oh, it's a 1.
Madam Hearing Officer, the chat's been enabled for everyone, so we can all see it.
Okay, great. Thank you. Anything further from any council or parties? No. I'm going to turn to questions from the board. While I'm doing that, if you're on the platform as an attendee and would have a question, please reach out in the chat. Madam Chair, do you have questions of Ms. DeVore?
Yes, thank you, Madam Hearing Officer. I just have a few follow-up for Ms. DeVore. Thank you again for your testimony, Ms. DeVore. Appreciate it. How many national parks are also in Colorado?
4 national parks in Colorado.
And can you just share with us the general location of those parks? Like, is it in the north, south?
So there's Rocky Mountain National Park, which is just to the northwest of Denver. And then there's Black Canyon of the Gunnison, which is just to the southeast of Grand Junction and in the middle of the state. And then there's the Great Sand Dunes National Park and Preserve, which is just to the west of Pueblo. So it's into like the kind of southwest, south mid portion of the state. And then Mesa Verde, which has actually been discussed a few times in this rulemaking, which is in the southwest portion of Colorado on the border of New Mexico.
Thank you for that, Ms. DeVore. And I just asked that so I can get an idea as to where the general location of the parks are in Colorado. So in the Colorado rulemaking, did the National Park Service also have similar stances as I think Mr. Rose had mentioned from the National Park Service perspective regarding more stringent or stricter rules for Colorado?
So the National Park Service participated in the stakeholder process for Colorado's engine rulemaking. They ultimately did not file to be a party. I think because of some of the differences in the language and the way that that rule was approached, there were similar comments about lower standards for future rulemaking. So Colorado at the time, the way things work is with engines with lower horsepower weren't considered as part of the scope of that rulemaking. So if something's not part of the scope, and other parties did this too, where, oh, we have comments about this, and it's like, well, but we're only looking at this scope. And so Colorado at the time said, okay, we'll think about that for the future. So it's similar to what I echoed today for New Mexico.
Thank you for that, Ms. DeVore, that clarification. So in some of the national parks in Colorado, are there similar concerns in terms of air quality because of oil and gas activities as well?
So for Rocky Mountain National Park, and then I should also mention there are 2 national monuments in Colorado. I apologize, I didn't say that a little earlier. We have the monuments and the parks. So Dinosaur National Monument is in the northwest corner of Colorado, and they're very close to a large oil and gas basin as well. And the Colorado National Monument, which is pretty much in Grand Junction, also faces some similar challenges. So we are seeing, and Mesa Verde is in fact impacted by oil and gas from the basin next to it as well. So we are facing a lot of these dilemmas, albeit on different scales, but we do see them in other parks in Colorado.
Okay, thank you. And then, so just in terms of the national parks position on this, as Mr. Rose mentioned earlier, is so as ongoing activities or I guess initiatives for the National Park Service, is there going to be additional and maybe that's maybe too far broad, but let me rephrase that. As Carlsbad Cavern is, I think, was a part of a lot of the testimony earlier on, but as well, I think you referred to it in your testimony this morning as the national park that the National Park Service has some additional data on. Do you foresee that this rule would help the National Park Service's air quality within the Carlsbad Caverns area?
All pollution reductions for NOx and VOCs will improve ozone. I think that more needs to be done. There's like a lot of different source sectors that need to be examined, but oil and gas is a part of that pie, and it will improve ozone if this rule's impact comes into effect.
Okay, thank you, Ms. DeVore. That's all I have for now.
Thank you. Vice Chair Trio Davis.
Yes, I have a couple of questions. Thank you, Ms. DeVore, for taking time to chat with us today. Is there a park-specific, a national park-specific initiative to reduce ozone in all national parks?
Not a specific initiative, but the Air Resources Division of the National Park Service works on air quality issues for the Park Service, and that division, which is a national office that I work with, believes that ozone and, so working on air quality issues that impact our parks is a priority for that division.
So outside of participating in rulemaking in various states, what other activities has a national park taken up to reduce ozone in their parks?
So one example would be for Rocky Mountain National Park, and actually there's a lot of parks throughout the nation. I just couldn't speak to those as specifically, but the Park Service has worked hard to do things like greener fleets, and there are a lot of parks have green teams to reduce impacts from within the parks on ozone, and for, like we've heard a lot during this hearing, so air pollution spans oftentimes multiple issues, so you may see like greenhouse gas reductions and also improve ozone. In Rocky Mountain National Park, we have issues with nitrogen deposition, which come from ammonia and from nitrogen oxides. So we try to look at that holistically, and then parks, oftentimes our larger parks, undergo the green opportunities to reduce their impacts to, like I said, issues such as ozone.
So would you say that participating in rulemaking is probably one of your biggest initiatives to reduce ozone?
I think yes, because oftentimes, the parks aren't the significant contributors to the ozone or whatever issue may be impacting that park. So we try to participate in hearings. Another example would be for regional haze, where we are participating across the US. That's stipulated in that rule for, states when they're working on their plans about which sources contribute to regional haze, which is basically visibility at the parks.
Okay, the National Park Service is part of the Department of Interior, is that correct? And BLM is also part of that as well? Okay, I was trying to understand the structure. So thank you, I don't have any more questions.
Thank you.
Member Cates? Member Bitzer?
Yeah, thank you for your testimony. I think it was Council Mr. Rose who had asked if your presentation was the official position of the Park Service. And was that a yes answer that you gave?
Yes.
That's all I have. Thank you.
Okay. Thank you.
Thank you. Member Garcia?
Yes, thank you. And thank you for being with us today, Ms. DeVore. You made a statement in the very beginning, which really struck me, and I want to make sure I got it correctly. Did I hear you say that the air quality around Carlsbad National Caverns was on the order of the air quality in Santiago, Chile, and Mexico City? Did I hear that correctly?
Yes.
Wow. I travel to Mexico City fairly often, and it's pretty horrible. So that's quite a statement. Do you mean in terms of a particular constituent or just general smog?
So in terms of ozone, so we're seeing the frequency of the elevated ozone levels in Carlsbad. It's bad as those other two cities that you just mentioned. In terms of like in VOC levels.
Thank you.
Mm-hmm.
Member Honker?
Thanks for your testimony, Ms. DeVore. I have no questions.
All right, thank you. Ms. DeVore, is there anything else at all you would add based on the questions you've been asked by the parties and the board?
I think the only other thing I would add is that the council board member Davis's question about how the Park Service participates. So I did neglect to mention that we also participate in what's called prevention of significant deterioration reviews. So that's when large facilities are built within a certain distance from national parks. We do weigh in on those permitting processes. So, and then we also work on what's called National Environmental Protection or Policy Act. So when we see activities within a certain distance of national parks, and this can range from oil and gas leases to mining leases, or a couple of examples. That rule is very broad. For example, there's a highway near one of our parks in Arizona. We give input into those processes as well, just for additional context on other things that we work on with air quality priorities.
Thank you. Vice Chair Taylor Davis, anything further based on that?
No, thank you for the additional information.
Thank you. Thank you very much, Ms. DeVore. So let's see, the two parties I remember with rebuttal or surrebuttal to the National Park Service was the department and NMOGA. I will certainly give you the choice, Mr. Heiser and Ms. Katz, to do this later if you'd like to leap into LDAR sooner rather than later, or you can do it now.
I don't think that we have very much time, Madam Hearing Officer, on this. I don't know about Ms. Katz.
Okay. Ms. Katz? Let's see.
I believe our presentation would be very short on this topic.
Okay. So we can certainly go ahead and do that. Mr. Rose, I see you on screen.
Yes, we had rebuttal testimony in response to the Park Service as well. We've reviewed that and are withdrawing some of that rebuttal testimony, which we'll have revised. And that's Mr. Blewett's rebuttal testimony addressed the Park Service proposal, and we'll be filing revised rebuttal testimony, withdrawing some of his comments on the Park Service proposal. Hopefully, if we get a break, doing it during the break here today.
All right, thank you for that. So do I take it, Ms. Katz, that you'd like to do that rebuttal now?
Madam,
Yes, we can.
I'm sorry. So,
Madam Hearing Officer,
oh,
yeah,
Mr.
this is David Bach. I wanted to flag, I believe we had mentioned that we did want to put on a, I guess it's a SIR rebuttal witness to the changes that were made in the rebuttal version of the NMED provision. It's not going to take very long, but our witness is not available today. He would need to, it's Dr. Daniel Orozco, I believe we had mentioned, and he would be testifying tomorrow.
That's fine. That's fine. I'll make a note to loop back to Mr. Orozco. So, Ms. Katz, I did.
Testimony did come, Madam Hearing Officer. We'd prefer to wait till it's all in so that we can respond to it.
All right, thank you. Ms. Katz?
I guess that's probably, yeah, we should probably wait as well then.
All right. Great. So let me see if Ms. Solaria would like to join us for a discussion and let us know how she would prefer to advise the board. Ms. Solaria, I see you on the screen.
Hi, good morning, Madam Hearing Officer and board members. As the hearing officer mentioned earlier, I have not been on screen. I have been here present throughout the proceedings, and I did appreciate the board's inquiry about how we were going to handle her recent ruling regarding potentially, well, her ruling was to exclude certain evidence proffered by NMOGA on SIR rebuttal on the basis of unfair surprise to the other parties. My advice at present, to avoid essentially derailing the presentation of testimony for a mini hearing on the legal purpose of that exclusion, was to proceed as the hearing officer suggested, where the NMOGA would proffer on the record what has been ruled to be excluded. So all of that is going to go onto the record with essentially the caveat that it's not admissible at this point. I think while it was suggested that you all take up the legal argument about the exclusion now, I just don't think that's practicable at this point. I think that's more appropriately reserved for the parties to brief post-hearing, and you would essentially take up the reconsideration of the motion that was ruled upon at the top of your deliberations. So when you meet to deliberate, you will reconsider the hearing officer's ruling on that motion. You can uphold it, you can reverse it. In the event that you reverse it and decide that NMOGA's proffered SIR rebuttal should have been admitted, you can consider it in your deliberations. And the rules also permit you to reopen the record if you decide, hey, we're going to let this evidence in, but we want to give the department and other parties a chance to then respond to that. But these are all considerations that you can discuss freely during deliberations. I just don't think it's practical at this time, and I think you should have the benefit of sitting with the proffered evidence and the arguments that the parties would present in their post-hearing filings. Does anyone have any questions for me?
This is Matt. This is Phoebe. Thank you, Ms. Solaria, for that clarification. I think that helps us all figure out how we move forward on this. And And no, I see every of the board members shaking their head. Yeah. Okay. Sounds good. Thank you so much.
And the other this is more of a suggestion to the hearing officer and the parties, is that if the hearing officer is agreeable, that we take a short break so that the council can specify what is being proffered and what is being, well, essentially have a list of what's being proffered based on the hearing officer's order, because I don't think that was clear during the earlier colloquy. And it would just be more efficient for council to do that before Mr. Smitherman is put on.
Thank you, Ms. Solaria. I think I also support that because it did sound like there was some different or confusion, if you will. And also, I think that would be helpful prior to Mr. Smitherman coming on. Just that clarification. And no, I'm looking to the other board members if you have any comments on that as well. Sounds good.
I support that.
Me too.
All right, so it sounds
Hearing
like
officer, this is Eric Heiser for Namoga. We will work obviously within the direction of the board and that you've provided, but I think that it'd be appropriate to move Mr. Smitherman back because we obviously need to now develop, a proffer as well as try to participate in the hearing. But I do remind you that he's not available tomorrow.
okay, thank you.
Madam Hearing Officer?
Yes.
This is Madam Chair. And thank you for that, Mr. Heiser. I think, and I appreciate that, that information just so that we know the constraints and of Mr. Smitherman's availability. And I think we're all just trying to navigate this and trying to make sure that we're inclusive as appropriate. Thank you again for working with us.
All right, thank you. So let me ask if this would be a good time for a break or whether it's preferable to hear from the department for a little bit before breaking. Ms. Katz?
I guess I would leave that up to everybody else in the court reporter.
All right.
Yes, we've been going for almost 2 hours, so I would like a break.
That's right. That's right. We did get on at 8:30, didn't we? All right. Let's take a longish break then, so that council can consider the slides, for example. Let's come back at 10:45, and we'll start with the department.